Okay, good afternoon, everybody. Looks like we have some of the inmates here and the attorneys present, so we can go ahead and get started. They're running a little bit behind on getting the females in here. For those of you who have female clients, just hang tight. My name is Judge Esparza. Today is June the 18th, Tuesday. We have some writ hearings scheduled. We do not have a court reporter. If you are requesting a court reporter, your case will be rescheduled for a later date. Not hearing any objections, we will proceed. The first case I'm going to call is C 2738-24-E, State of Texas versus Brian Colunga. Colunga, you're fine right there, sir. I think we can see you from there. You're good there. And you speak English, correct, Mr. Colunga? Mr. Colunga is present. Mr. Whitaker, this is your motion. Who's here for the state? Ileana?
Good afternoon, Judge. Over on behalf of the state.
Thank you. Mr. Whitaker, this is your motion.
Howdy, Judge.
Proceed.
Okay, what we have here, Judge, is a gentleman who apparently tried a suicide by cop. That's the underlying allegation, although it doesn't actually say that in the PC statement, but one can make it out in essence. But that's what we have. He took 6 bullets at either inside or outside the lobby of the McAllen PD. He basically has necessity to do basic life functions with assistance, Judge. He needs assistance with eating, with mobility, with reading, changing his bandages, cleaning his wounds, and basic hygiene related to urination and defecation, Your Honor. Basically, that place, the infirmary, is not designed for this. He should be in rehab and occupational therapy, to be specific. I realize that may have been true, and all of it is a horrible crime, and the cop will have all kinds of issues, but I don't think he's going to be a present danger to McAllen PD in his current condition, Judge.
What are you asking, Mr. Whitaker?
Ms. Lopez can inform if she has some cash. This is considered an assaultive offense, so we're going to need a bond, Judge. Even if you wanted to give him a PR bond, we'd still need to give him a financial bond, I believe, by law. So, Ms.
What are you asking? Hold on, before I hear from her, have you spoken to her? What are you asking on the bond?
I don't know why I can't find that in my notes. That's the issue, Judge. I'm actually literally looking for that amount, and I don't have it right in front of me. So,
okay, what's the state? What's the state's position?
Your Honor, the facts of this case are very concerning, Judge. The defendant is considered a danger to the community, Judge. He has a lengthy criminal history. He has one prior trip to TDC, and he'll be charged as a repeater, Judge. So at this time, the state would be opposed to a bond reduction in this case.
Of course, they're opposed to any bond reduction, Your Honor, because he's a threat to the community in a wheelchair.
Hang on. Mr. Colunga, raise your right hand, sir. I can't. You swear to tell the truth, just the best of your ability. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
What's your name?
Brian Colunga.
How old are you, sir?
31.
Are you able to get up out of that chair?
No, sir. I got.
You're not able to get up, correct?
Yes, sir.
Judge, if there are any steps.
Mr. Whitaker, give me a minute, please. Prior to being arrested, where were you living?
Next with my mom.
What city?
Got it.
Are you married?
Yes, sir.
Your children?
Yes, sir.
How old are they?
10 and 9.
Who do they live with?
My big mama.
Did you have a job prior to, where were you working?
They pop chicken.
All right.
They pop chicken.
What'd you do there?
I was prepped.
And if you are released, where will you be living?
My mom. No one is gonna take care of me.
All right. Sir, if you do make bond, I'm gonna order a curfew. You can't be out of the house past 8 p.m. No early, from 8 p.m. to 7 a.m. unless you have doctor's visits or what have you. You understand?
House arrest.
It's basically what it is. You have a curfew, 8 p.m. to 7 a.m. I'm also going to order AIP, which means probation officer will go check on you periodically, make sure you're at home. If you're going to leave to go to doctor's visits or whatever, you just need to notify them ahead. Let me finish. Notify them where you're going, and they'll allow you to go to doctor's visits, wherever you need to go, as long as you notify them. You understand?
Yes, sir. Can I ask a question?
Hang on just a minute. I think your attorney may want you to just wait on that. Lopez? She on the line? Can you?
Yes.
unmute yourself?
Yes, I am.
Ma'am, would you state your name, please?
Deborah Lopez.
How are you related to Mr. Colunga?
He's my son.
Okay. And if he's released from custody, will he be living with you?
Yes, he will.
What city is that in, ma'am?
McAllen.
Okay. Are you able to make any type of bond, financial means to make bond on this, any type of bond?
Honestly, I'm not, I don't have the means, but I mean, if I have to borrow or something to make bond for him, I will.
All right. Bond is currently set at 300,000. Bond will be reduced to $10,000 cash surety.
Thank you, Your Honor.
He's under, understand he's under a curfew, 8 p.m. to 7 a.m. I realize his condition there. He's not to be out of the house past 8 p.m. prior to 7 a.m. in the morning, unless he's at a doctor's visit or in a hospital or somewhere else confined. Other than that, he needs to remain at the house.
Yes, sir.
AIP officers will go in periodically to check to make sure he's at location or doctor's visits wherever he's supposed to be. And if he's not, he's gonna have a problem and he may end up back in jail. You understand that?
Yes, Your
What's your
Honor.
question, sir?
Tropical, what number am I could go to?
If you have an appointment and they allow you to go there, you need to call first. If they allow you to go there and you have an appointment, you contact,
He's hoping to go.
listen to me, you contact the AIP officer and you give him a copy. Don't just tell him, you're gonna have to give him something in writing saying that you have an appointment. If he okays you, then you can go. Do you understand that?
Yes, sir.
All right.
She said, once I come out to report over, to let her know.
Anything else, Mr. Whitaker?
Nothing further, Your Honor.
All right, have a good afternoon. Thank
Thank you,
you.
Judge. Have a good day,
Thank
sir.
you.
You too. He may be released, well, you can't leave, right? Okay, all right, you're done, sir, you're good.
Thank you, sir.
Just hang tight, just stay there for a little while. Let's see, who else is on here? Mr. Ortegon, get on. Jorge, there you are. Okay, the next
I'm here,
case we're
Judge.
gonna call is C 2640-24-C, State of Texas versus Luis Escobar. Mr. Escobar is present in the courtroom. He is Spanish speaking. I'm not sure if you're aware, Mr. Ortegon, but he does have an ICE hold.
Just my luck, Judge. I'm noticing that's happening quite a bit. I guess they're getting the holds after we file the writ. Either way, Judge, if we can urge the writ, Your Honor, his bond is currently set at 20,000. He is indigent, Judge. Obviously, we know he does have an ICE hold, Your Honor, but we do believe that the bond is excessive for the charge. And we would respectfully request any consideration on a reduction, Judge, preferably, maybe a $1,000 to $5,000 cash surety bond as opposed to a $20,000 cash surety bond. This is an unauthorized use of a motor vehicle charge, Judge. It's a nonviolent offense. And as this honorable court knows, if he is to make bond and they are going to potentially let him stay, he's going to have to pay 100% of that bond, Your Honor. So we would respectfully request that be reduced to something reasonable. But we obviously do understand the court's concern with the ICE hold, Judge. That's why we're asking for a cash surety and not a PR.
What says the state?
Your Honor, obviously the state would be opposed to a bond reduction, Judge, given the immigration hold and the immigration hold, Judge.
Mr. Escobar, raise your right hand, please. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name. How old are you? Do you have family in Hidalgo County? What city were you living in before you were arrested? Who were you living with?
Uncle.
I have family here. Bond will be reduced to $3,000 cash surety.
Thank you, Your Honor.
No contact with the victim. Don't go back to that location. I believe you were working there, but I don't think they're gonna want you back there. Who knows? But don't go back there. You understand? You understand? All right. Anything else,
May I be
Mr. Ortegon?
That's all I have with this honorable court, Judge. May I be excused at this time?
Sir, have a good afternoon.
Likewise, Your Honor.
Next case we're gonna call is C 2755-24-F, State of Texas versus San Juanita Herrera. John Rodriguez, there you are.
Good morning,
Mr.
sorry, good
Hernandez.
afternoon, Your Honor.
You speak English, Ms. Herrera? She is present in the courtroom. She does speak English. You may proceed, Mr. Rodriguez.
Thank you, Judge. Ms. Herrera is currently before this court on 2 charges, Your Honor. They are both possessions of a controlled substance, penalty group 1B. One is between 1 and 4 grams, that is currently set at $15,000. And the other one is a less than 1 gram, same possession, 1B, and that is currently set at $10,000. Ms. Herrera does not have an extensive criminal history. She does have 1 prior for possession of a controlled substance, penalty group 3, which was a deferred adjudication that she did complete. We're asking this court to consider reducing the current bonds, as we believe that they are above her means in order to receive 2 PR bonds, Your Honor. We're asking for the possession of a controlled substance with 1 to 4 grams to be set at $5,000 PR bond, and the other possession of controlled substance of less than 1 gram to be set at $1,000 PR bond.
It says the state.
Your Honor, at this time, given that the defendant does not have an extensive criminal history and given the charges judged, the state is amenable to PR bonds.
And raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God? State your name. How old are you?
I'm 25.
What city do you live in?
I live in West Coast.
Who do you live with?
I live with my mom.
101 South Republic?
No, 114 North Pino.
Say it again, 114 what?
North Pino.
North Pino?
Yes.
In Westlaco?
Yes.
You sure when you're released that you give them your proper address? Because at some point you're gonna get a letter from the courthouse to show up, and if you don't give them the correct address and don't show up, they're gonna issue a warrant for your arrest. You understand that?
114 North Pino.
114 North Pino. John, you have that address?
Yes, 114 North Pino. The only thing I'd remind her, with the court's permission, is that as soon as she gets out, she gives me a call.
She has your contact info?
Yes, Your Honor, she's
Okay.
received it already, she's been served at the jail.
Ma'am, I'm gonna go ahead and reduce your bonds. You will be released. Stay in contact with your attorney every week or every month. You get a hold of him. You understand?
Very good, Your Honor.
Bond on both charges will be reduced to $1,000 PR on each charge. No more drugs, no alcohol. You understand? Thank you, Mr. Rodriguez.
Thank you, Your Honor. Have a great day, Your Honor. Thank you, Ms. Sepulveda.
Next case we're gonna call is C 2786-24-F, State of Texas versus Roxanne Reyna. You speak English, Roxanne?
Yes, sir.
Ms. Reyna is present. Rolando Cantu, she not on the screen. I thought I saw him. Oh, there you are. Okay.
Very
so,
good.
It's your motion, sir. You may proceed.
Runner, Dana Judge, she currently has 3 charges before the court. She just got arrested on. She's been in custody for about 6 days now. She was booked in on June the 12th. She does have a possession of controlled substance. Her bond is at $2,000. She did pick up a DWI 3rd or more. Her bond at $5,000, and then a Class B possession of marijuana less than 2 ounces. Her bond's at $1,000, Your Honor. That's a total of $8,000 for all three. Your Honor, she is indigent. She does not have the means to make this bond. She also has a couple of pending cases out of the 93rd, I believe. That I was court appointed on, as well as an aggravated assault and also possession of controlled substance. She has a July 1st setting on those cases, Your Honor. I don't see a verification of incarceration has been filed. She did bond out on those cases, so she was out on bond when she picked up these new offenses. She is a U.S. citizen, Your Honor. She's a resident of Alton. We're asking the court to consider pure bond for her, Your Honor, given the fact that she's been in custody for 6 days and she's been unable to make this bond.
What says the state?
Your Honor, at this time, the state would be very opposed to a bond reduction in these cases, Judge. She does have, as Mr. Cantu stated, an aggravated assault with a deadly weapon, a burglary of habitation, and a possession of a controlled substance. Felony charges already pending, Judge. She was out on bond. She picked up new offenses. And the state believes that the bonds are reasonable as they're set at this time, Judge. So we'd be opposed to reduction.
Ma'am, raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God? State your name. How old are you? Speak louder, please. You can put your hand down. Do you work, ma'am?
At the moment, I am disabled. I'm not working. That's enough.
What was the last job you were working at?
I'm medical assistant.
How long ago was that?
A year and a half.
Are you married?
No, sir.
You have children?
Yes, sir.
Where are they at? They with you?
Yes, sir.
How old are they?
17 and 14, my boys.
Where are they now?
With my mom.
The magistrate who arraigned you on the DWI charge ordered that you get an alcohol monitoring device. If you're released or make bond, you've got, I believe it was 5 days he ordered. Let me check real quick, he ordered. You've got 10 days upon release to get a portable device that you need to carry around with you at all times and blow on it 3 times a day, between 6 and 8 in the morning, between 4 and 6 in the afternoon, between 10 and midnight at night. If you're using alcohol, it's going to be reported back to probation. They're going to notify the court and possibly revoke your bond, and you end up back in jail. Do you understand that? No drinking, no drugs, no alcohol. Is that clear? Bond on the possession charge will be reduced to $2,000 PR. Bond on the possession of marijuana charge will be reduced to $1,000 PR. Bond on the DWI charge will be reduced to $3,000 cash surety. Random erase through probation. So probation may contact you to go in and get drug tested. You come back positive, you're gonna end up back in jail. Is that clear? Anything else, Willie? Mr. Cantu?
That's it, Judge. Thank you.
All right, have a good afternoon. Good luck to you, man. The next case we're gonna call is C 2748-24-E, State of Texas versus Bobby Ochoa. Speak English, correct, Mr. Ochoa? Mr. Ochoa is present. Veronica Martinez, good afternoon. This is your motion. You may proceed.
Your Honor, Mr. Ochoa is charged with manufacturing delivery of a controlled substance, penalty group 1, between 200 and 400 grams. The bond's currently set at 35,000 cash surety, Your Honor. There were other individuals, according to my client, that were in the vehicle. The drugs were not found in his possession. In speaking with his family, they can't afford a small bond. We would respectfully be requesting a reduction to 2,500 cash surety.
What says the state?
Your Honor, the defendant in this case has a U.S. Marshal hold for a supervised release violation. He was previously placed on supervised release for federal alien smuggling conviction. He also has a lengthy criminal history, and he's a habitual offender, so he has 3 prior trips to TDC, Judge. So at this time, the state's position is that the bonds are reasonable as they are, and he would be close to reduction.
I'm not sure if you were aware about the marshal. I meant to tell you that, Ms. Spuga.
No, Your Honor, I was not aware of that hold.
Sir, Mr. Ochoa, there's a hold from the U.S. Marshals, so even if you were to make bond, you wouldn't be released, you'd be released to the marshals. You understand that? For a parole or probation violation. Regardless, raise your right hand, sir. Swear to tell the truth, the whole truth, and nothing but the truth, so help you God? State your name. Put your hand up. Are you on parole or probation with the feds?
I'm on federal probation and state parole.
Okay. And were you reporting? What city do you currently live in? Who do you live with? Can't hear you.
With my family.
How old are you, sir?
32.
32? I'll go ahead and reduce the bond to $2,500 cash surety. Understand, sir, if you do make bond, they're going to turn you over to the marshals. Right? Anything else?
No, that's all, Your Honor. And I'll let his family know about the hold. Thank
All
you.
right, thank you. Have a good afternoon. Good to see you, sir. Good luck to you. Yes, thank you. Case we're gonna call is C 2736-24-C, State of Texas versus Ando Ramon.
Spanish speaking.
Okay, Mr. ¿No habla inglés, señor? ¿Habla inglés?
No.
Okay. Mr. Ramon is present. He is Spanish speaking. Nereda, I ask that you go slowly so that the interpreter can translate everything
Yes,
for
sir.
us.
Yes,
Ready?
sir. Mr. Ramon, Judge, tells me he was born in Mercedes. He is a U.S. citizen. He is charged with assault on a family or household member. It's a 3rd-degree felony. Judge, he has a bond of $25,000. It is a number that he cannot make. He works and has a job waiting for him. Oh, I'm sorry. I think I may be going too fast. He works in a taqueria, Judge. He is also the caretaker of an adult disabled stepchild. His wife passed away recently and left him in charge of this adult child. And we're asking respectfully that the court consider reducing the bond to $2,000 cash or surety.
What says the state?
Your Honor, this defendant is a repeat offender, Judge. The state would be opposed to a bond reduction given that fact. And if the, well, just for the court's information and defense counsel, there's a emergency protective order that's active.
Yeah, I'm sure if you were aware of it, but there is a protective order. Make sure you tell him, Adrian, that there's a protective order issued. He is not to have any contact with Ociel Cantu. He's not supposed to go within 200 yards of the address located at 12625 Creek Place in Mercedes. The protective order is effective until September 3rd of this year, 2024. Raise your right hand, sir. You swear to tell the truth, so help. You swear to tell the truth, nothing but the truth, so help you God.
Yes.
What's your name, sir?
Fernando Ramos Olivo.
What city do you live in?
En Mercedes.
What's the address where you live at?
2646 Creek Place, 446 Mercedes, Texas, 7870. Sorry.
That's not the same address on the protective order. Who lives at 12625 Creek Place?
He says like esos sociales there.
Is that your neighbor?
No, it's not. su hijo? Sí, el pelado.
Stepson.
It's a different address. Does he live with you or a different address?
Judge,
There may be a
if I
problem.
may, no, if I may clarify, Judge,
Okay.
he has two stepsons.
Okay,
One is Ociel, he is the disabled one, and the other one, his name is Ilario. Ilario has been having a lot of problems with the law and doesn't like my client. When Ilario feels like it, he will use his brother's name. If Ociel were really the victim, we would have an injury to a disabled person because Ociel is disabled. We
okay,
don't.
well,
We have assault.
there is a protective order that was issued by JJ Peña, so you may need to get that clarified. He's the only one that can modify it. So if your client does make bond, you'll need to contact Judge Peña's office and provide him the documentation to see if they'll modify it, because if he goes back to that address and there is an active protective order, he will be arrested again.
Yes,
Okay.
I understand.
I'll go ahead and reduce the bond to $2,000 cash surety. Read my mind, that was the number that I had in mind. Sir, at this time, there is a protective order. You're not to have contact with Ociel Cantu. Now, your attorneys explained that there may be some confusion there, but until that protective order is modified, you cannot go back to the address at 12625 Creek Place in Mercedes. Do you understand that? So if you make bond, the first thing you need to do is contact your attorney. Is that clear?
Please.
All right. Anything else, Maria?
No, Judge, that is all I have. May we be excused.
All right. Yes.
Thank you, Judge.
Thank you. Tracy, you on there? There you are. Okay, the next case we're gonna call is C 2683-24-A, State of Texas versus Alejandro Cantu. Speak English, Mr. Cantu? Mr. Cantu is present in the courtroom. Hang on just a minute.
Yes,
Sir
Judge.
Maria Garcia. Hold on just a minute, Tracy.
Okay.
Did y'all get a hold of it? Save It's well done. Trying to do. I apologize. Mr. Cantu is present in the courtroom. He is English speaking. It's your motion, Tracy. You may proceed.
Yes, Judge. Mr. Cantu is there on two different counts. Count one is a second-degree felony, the tampering, fabrication of physical evidence with intent to impair a human corpse, Judge. That bond is currently set at $1 million. The second count he's there for is an aggravated robbery. That one is the F1 judge. He's there on a bond of $50,000. He's been in jail since May the 22nd. He is a United States citizen. He graduated from high school in Weslaco back in 2012. He is a widow as well, Judge. He does have full custody of a 10-year-old boy. Currently, that child is residing with his family in Dallas once he was arrested. He had no prior criminal history, Judge. He's never been arrested before. These two cases are not from the same transaction. The facts have nothing to do with each other, and the allegations on at least the tampering with the human corpse, Judge, that case involves a murder that my client, at some point, they're alleging that he went to a location where there was an excavator. He was at that location when it was either picked up or purchased. And I believe that's on the allegations that they have. They're not necessarily alleging that he used it, that he participated in the murder, that he knew about the murder. They're alleging that he was there when him and some other individuals picked up this equipment from us or rented it from a store. To my knowledge, Judge, that is the information on that. I'm not really sure how the aggravated robbery, the facts are alleged on that one, but that is something that was out of a different transaction. So, Judge, we would be asking that the bond, again, the tampering, that's a second-degree felony. So we would be asking that the bond be set at $20,000, Judge. And on the aggravated robbery, Judge, we'd be asking that the bond be set at $25,000 cash, especially since he has no priors.
Says the state.
Judge, the facts on this particular case, the tampering with the corpse are concerning for the state. Given that these offenses were committed within days of each other, Judge, the state would be opposed to a bond reduction in these cases.
Raise your right hand, Mr. Contreras. Swear to tell the truth, the whole truth, and nothing but the truth, so help you God. Yes, sir. State your name. Alejandro Cantú. How old are you, sir? 29. What city do you currently live in? You rent or own? Buying a home? Yes, sir. Where do you work? I do maintenance on automotive equipment, like lids, air compressors, etc. Who do you work for? Texas Lift Tex. Where is that located? It's like valley-wide, and they go nationwide. How long have you been working for them? 7 years. I didn't see any prior criminal history on him. Is that correct? Deanna?
That's correct, Judge.
Bond on the ag robbery be reduced to $25,000 cash surety. Bond on the tampering be reduced to $50,000 cash surety. Sir, if you make bond, contact with the co-defendants on the tampering charge. No leaving the county either. Do you leave? You all work all over the valley from Cameron County, or where you just work in Hidalgo County? I mainly work here in Hidalgo County. I have to stay here. It's just all right. No leaving the county.
Your Honor, and if he can be ordered to stay away from the victim in the aggravated robbery, Judge.
No contact with the alleged victim on that robbery charge. You understand? Don't contact her family. Don't contact her friends. Don't contact anybody associated with that case. Is that clear? We get information that you're going to end up back in jail. Is that clear? Simmons, anything else?
No, Your Honor, that's all I have.
All right. Good luck to you, sir. Have a seat.
You just may be excused.
Yes, thank you. Next case we're going to call is C 2752-24-J, State of Texas versus Maria Isabel Garcia. You speak English, Ms. Garcia? Yes. Sergio Munoz, no answer?
No, sir, we put a sticky note.
Oh, sorry.
Sorry.
Doctor's appointment. Okay, Mr. Munoz is not available. He's asking that this case be reset to the 25th. Did the state did you have a chance to speak to Mr. Munoz?
No, Judge. I don't believe he reached out to our office, Judge, to confer on this case.
Do you have a recommendation?
Your Honor, we are not, we are opposed to a reduction in this case. She does have 1, 2, 3, 4, 5, 6, 7 cases pending, Judge. When she picked up these new charges, so the state would be opposed to a bond reduction, given that she's already been given a chance to be out on bond. And
Raise your right hand, man. Swear to tell the truth, the whole truth, and nothing but the truth, so help you God. State your name. How old are you, man? What city do you live in? You married? Children? How old are they? They're all adults? You work?
Yes, sir.
Where do you work?
I work at it's a drive-through store.
What's it called? Okay, convenience store? You work full-time or what?
Yes.
You had a job before you came in custody? You've got some pending charges, man, that you need to make sure if you get out on bond, you stay in contact with your attorney. Do you know who your attorney is? Who's your attorney? You've been in contact with him?
Yes, it's very hard to get a hold of him, but I speak to his assistant.
Staff, okay. I'm gonna go ahead and reduce your bond in this case to $1,000 PR. Which means you'll get out with your signature. We'll also order random UAs through probation. Probation will contact you to go in and get drug tested. No drugs, no alcohol. You come back positive, you're gonna end up back in jail, no more bond reduction. You understand? All right, good luck to you. Anna, thank you for your help. Have a good afternoon.
Thank you, Judge.
Bye-bye.